Learned counsel for the appellant complainant has strongly opposed the acquittal of the accused persons. He took the court through the evidence on record and urged that the recovery of the robbed articles itself should be a sufficient ground for a conviction, though it is further supported by other circumstantial evidence. He further argued that the High Court in its majority opinion erred in giving undue importance to small shortcomings in the investigation, because of which justice had to suffer. He also argued that the last seen evidence of PW 12 and PW 20 along with the evidence of recovery of the stolen ornaments and cash at the instance of the accused persons from their possession is not to be ignored. He placed reliance on the recovery of the key used to lock the house from outside after the commission of the crime at the instance of the first accused, and said that the recovery of the same is conclusive proof of the participation of the accused persons in the said offense. He also argued that finding blood of the Group O on the clothes of the accused in light of the recoveries made could only lead to one conclusion, i.e. the guilt of the accused, since this was also the blood group of the deceased persons. However, he admitted that the fingerprint examination report could not be relied upon, and that the hair sample test report was inconclusive. The state of Madhya Pradesh has also filed an appeal against the acquittal by the High Court. The learned counsel for the state, while adopting the arguments of the counsel for the complainant in opposing the acquittal, submitted that the circumstantial evidence on record, which is fully proved, would only lead to the conviction of the accused. The Supreme Court Legal Services Committee was directed by us to engage a counsel for the accused respondents since none had appeared for them. An amicus curiae was appointed to assist us in relation to the arguments for the respondents. He supported the majority view taken by the High Court in acquitting the accused persons in entirety. He argued relating to the arrests made and the alleged recoveries made by the police at the instance of the accused. Learned amicus also stated that out of the recovery witnesses, who are all relatives of the deceased, only PW 26 has been examined. The non-examination of other witnesses, especially one Bahadur Yadav, the only independent witness, a servant of Prem Chand, who had allegedly assisted the police in the identification of the recovered ornaments by the mortgagees, was said to be crucial for the prosecution case. He further argued that no proper procedure was followed for the identification of the ornaments by the mortgagees, and the police had taken active interest in the identification of the ornaments, which was suspicious. Lastly, he submitted that the last seen circumstance was not proved. In a case wherein the High Court has acquitted the accused of all charges, there is a double presumption in favor of the accused, as the initial presumption of innocence is further reinforced by an acquittal by the High Court.